We are a vibrant and dynamic boutique legal practice located here in the beautiful town of Clonmel, County Tipperary. Founded by our senior partner, John M. Lynch, we have a strong expertise in areas of insolvency, family law, wills and probate, property services, medical negligence, personal injuries and litigation.
As a legal practice, we're at the cutting edge of technology. We became one of Ireland's first paperless legal firms as far back as 2006. We use voice recognition software to make our document production more efficient. We have recently introduced firm-wide workflows as a further step in enhancing our service delivery. We are more than happy to share our knowledge and legal know-how via our website, information packs, and our weekly radio programme on Tip FM each Tuesday at 10 a.m. As a firm, we all share a keen interest in the study of law. We have personnel with first-class honours degrees, honours master's degrees, and various specialist diplomas in all our areas of practice. We have built a strong team over the last number of years and continue to invest in that team for the benefit of our clients. We embrace challenge and are not afraid to take on the difficult cases that other firms may shy away from. We offer our service to local, national and international clients through the medium of modern technology and modern means of communication.
We are a forward-thinking law firm, committed to ongoing improvement. We continue to invest in the empowerment of our team, supporting learning by in-house team meetings, lectures, certificates and diploma courses. We are particularly interested in the direction that our modern world of social media is taking in the delivery of our services.
We strive for excellence in both our legal know-how and our service delivery, and our key focus as a professional practice is to deliver the best possible service to each individual client.
We have been giving reliable, quality legal advice to our clients for over 35 years and look forward to doing so for another 35 years.
What is medical negligence?
Medical negligence is an area of law which is rapidly expanding at the moment, and it basically happens when your healthcare professional or your healthcare provider offers you or provides you a standard of care which falls below the standard of care. That means the treatment they have given you is below the acceptable standard of care, or there has been perhaps an omission in such as delayed diagnosis in the standard of care which they have given to you. It applies not only to doctors or consultants, it applies across the whole medical arena. We have been involved in all types of medical negligence cases, such as women's health cases, that result birth injuries, such as cerebral palsy cases, obstetric cases, gynecology cases. Other examples would be orthopedic cases, eye injury cases, neurology cases. So it covers the whole medical arena.
What happens if a person falls into a pothole or trips over a defect in a footpath?
Yeah, very interesting area of law. The term that's used, which is a very, very old, archaic type of term, it's a principle of law called misfeasance and nonfeasance. It comes from, in case you're interested, it comes from the Latin verb of facio, which is to do something. And basically, if a local authority does something and does it badly, then they're liable. If they don't do anything at all, they have no liability. So it's a very old principle of law, and effectively it means that if you fall into a pothole that literally just comes, and it comes in a lot of roads around the country, you, as a general rule, won't have a case against the local authority. But if, on the other hand, they're doing road work, for example, and they dig a hole, and you fall into that hole and they don't warn you about it, well, then you have a cause of action. So that's putting it at its simplest those are the principles of law that are involved.
Why should I make a will?
You should make a will to ensure that your estate is divided the way you want it divided, and to ensure that the parties that you want to benefit from your estate benefit.
Who should I appoint as my executor?
You should appoint someone that you trust as your executor, because they are the parties who carry out the terms of your will. You can appoint a beneficiary under your will if you wish, so you could appoint your spouse or one of your children. You should ensure that the person you appoint is capable of dealing with the role that you are setting out for them.
Can I appoint my solicitor as an executor?
You can appoint your solicitor as an executor, and the solicitor will proceed to deal with the estate as per the terms of your will. They will include a charging clause in your will that allows for them to charge the estate for acting as your executor.
What is the difference between custody, access and guardianship?
Okay, if we deal with guardianship first, guardianship is it's the right to be involved in all important decisions regarding a child's upbringing, such as education, religion, where they live, any of those big, huge decisions. A guardian has a right to be involved in those. A guardian must also sign off on a passport application. A mother, by virtue of giving birth, is an automatic guardian. Where parties are married, the father is an automatic guardian. The father also becomes a guardian if the parties subsequently marry or after the birth of a child. In an unmarried situation, a father is a guardian, an automatic guardian, if he has lived with the mother for a requisite period of time, some of which must be the post-birth of the child. Access then is where the parents are living separate and apart, and one party is perhaps the primary carer of the child and the other party is given access. Custody is, I suppose, essentially the person who has the actual physical custody of the child, but at the moment I suppose there's more of a preference to use the word primary carer rather than custody.
How are costs in litigation dealt with?
The general rule is that they use the phrase costs follow the event. So as a general rule, if you take a case against somebody and you're successful in that case, then you'll get the cost, because the event is the case, you're successful in it, and then costs follow the event. So you get your costs. If you lose your case, well, in the event of your, no pun intended, but in the event of you losing your case, well, then you lose your costs. So you have to pay the other side's costs. And of course, not forgetting, you'll also have to pay your own costs. So that's the general rule when it comes to costs.
Can you give me examples of medical negligence cases?
We deal with all types of medical negligence actions. We have a specific women's health department, which I lead up, and we deal with all aspects of women's health. And I suppose this is a very sensitive area, which many people would prefer to deal with a mother or a female when they are discussing issues like that. We would deal with all obstetric type cases, childbirth injury cases such as cerebral palsy. We would have dealt with an awful lot of orthopedic cases, neurology cases. We're also involved in many cases involving the Dupuy hips, the cervical cancer cases and the narcolepsy cases.
What is the current status of the narcolepsy cases in Ireland?
The narcolepsy cases, I suppose, just to explain the background to them, they arise out of children who were essentially given the pandemic's vaccine, which was a vaccine which was brought in to counteract the H1N1 flu virus, which was also known as the swine flu virus. This vaccine was brought in, was given to these children, and unfortunately it was not properly tested according to our experts. These children, an amount of these children have gone on to develop narcolepsy, which is a lifelong condition. It is essentially a condition where children suffer from cataplexy, which is an inability to regulate their emotions, and it results in loss of limb control. Children may fall to the ground if they lose their emotions for perhaps they might have a laughing episode. There is also a sleep condition where these people affected by the narcolepsy can fall asleep suddenly and without warning. There is medication prescribed to attempt to limit the symptoms, but it's a lifelong condition. We act for quite a number of children who are affected by narcolepsy. Proceedings have issued, they're at an advanced stage, and these cases are currently involved in the discovery process. And this discovery process involves getting records to ascertain what testing went on, how these vaccines were tested before they were released onto the market.
What are the key stages in a purchase transaction?
In a purchase transaction, the stages are relatively straightforward, unless you want to drill it down to the small minutiae. Effectively, you agree the purchase of the property, you notify your solicitor. The solicitor for the seller will send the contract to your solicitor, i.e. the purchaser solicitor. You sign the contract. If you're getting a loan, you sort out getting a loan so that the loan comes to the purchaser solicitor. So you'll sign your loan documents and your contract at the same time. Contract is then sent back to the seller solicitor, who gets their client to sign it, and then you agree a closing date. Between the signing of the contract and the closing date, you have a stage called raising requisitions on title, and that's effectively just asking a series of questions which must be answered by the seller solicitor.
What happens when I become a bankrupt?
Basically, all of your assets are taken over by an official called the assignee in bankruptcy, and all of your liabilities are effectively written off. Your income is controlled by the assignee in bankruptcy. You're only allowed to earn a certain amount of money, and the balance of your income then is literally given to your creditors during the course of the bankruptcy. So you can have a bank account, but you must operate it in credit. You can have a job, but you're accountable for whatever excess income that you get. And you can't hold a directorship in a company. And it used to be that you couldn't be a local representative, but that's now been changed. And effectively you're registered as a bankrupt for a period of 1 year.